Hello class, hope you're doing well. Today we are going to go over Chapter 9, the courts, structure, and participants. So this is a long chapter and it's pretty detailed, so make sure you read the chapter, but we're going to go over kind of the main points of this chapter since there's so much involved here. So we're just going to basically go over a lot of terminology and some basic issues about how the courts in the United States are structured and who the participants are that work in the courtroom. So that said, we will start. And we have a dual court system in the United States. We have state courts and federal courts. And that's due to legislation that's been used because of the dual court system wanting to ensure that legislative authority and judicial autonomy would be used. That's why there's state and federal, because there's state crimes as well as federal crimes. So it separates those two types of crimes and systems, which is a good thing. As far as jurisdiction, you hear that term a lot. It basically means where the crime happened. So the jurisdiction of a case is going to be where the crime occurred, not necessarily where the person's arrested. So the original jurisdiction for a person that kills somebody in Nevada, but they're found in California, the jurisdiction is going to be in Nevada where the person committed the crime. So there's different types of jurisdiction, but basically it's determined by statute or constitution. Usually it means where the crime was committed as far as jurisdiction or territory. Going back to the early court state systems, they were not very uniform. Now the state courts follow the federal model, which we'll talk about in a little bit. So the three-tiered court structure involves trial courts of limited jurisdiction, trial courts of general jurisdiction, and then the appellate courts. And we'll talk about these. So make sure you read the chapter again. If you have any questions about these, make sure you put on the discussion board or let me know. And we'll get you through this. All of you soon-to-be attorneys out there will pay special attention to this in the next chapter. As far as state trial courts, basically they're limited or special jurisdiction, and they hear less serious criminal cases. General jurisdiction may hear any criminal case, and again, they can provide the first appellate level of court review. And so this is your basic courts, your basic misdemeanor and felony courts that we have. And they can also hear appeals for these cases. And we'll talk about appeals in a little bit. So the state appellate courts, though, they are a whole division. All they do is hear appeals. And you don't need to know the exact levels, but you need to know what they do. So the highest level of appellate court is the state Supreme Court in the state that you live. Also, it's known as the court of last resort. When we talk about appeal, it's a request from the person that was convicted that a higher court review the actions of the lower court. So the appellate courts, they don't conduct new trials. They just review the record of the case. They look back at what went on in the case, if things were followed properly and per the law. And most convictions are affirmed when they get to the appellate state. Those that are not satisfied with the results of the state court system, they can appeal to the United States Supreme Court, which is the highest court in the land. The highest court in the state is the state Supreme Court, but the highest court of the land is the United States Supreme Court. There's district courts for the United States, and these are federal courts. And basically, there's a lot of court work that goes on with federal crimes. Some concerns that the book talks about is the increasing caseload and the relatively low pay compared to other state or private attorneys that work in the system. The increasing caseload comes to the fact that there's not enough judges to hear the cases. So they're currently trying to put more judges to the bench in the federal courts to ensure that this caseload gets a little lower, because there are some determinations of how long a court case should take that is attached to one of our amendments, which we'll talk about in a minute. There is the United States Courts of Appeal, And you don't need to know how many there are or what they do, because they all do the same thing. And what they do is they look at lower courts' decisions and look at the case. Okay, they don't retry it, but they look at it for an appeal if they're going to grant it or deny it. Most appeals fall into one of three categories. First of all, it's frivolous, it's ritualistic, or it's non-consensual. And the book talks about what those categories mean. Again, as we said, the United States Supreme Court is the highest court in the land, includes the 9 justices and 1 chief justice. And this court, the United States Supreme Court, is the final interpreter of the U.S. Constitution. So every once in a while, we get an interpretation of a law or an amendment or something that is interpreted differently by the United States Supreme Court and creates a precedent decision. And those are uncommon, but it does happen. Okay, getting back to the court itself, the courtroom work group. It's basically 2 groups that participate in a criminal trial. First is the professionals, and and the book talks about the courtroom actors. I don't like that term because they're not actors, they actually run the place. So the actors are going to be the person that knows what they're doing. These are the attorneys, these are the judges, these are the bailiffs, these are everybody in the courtroom that knows what they're doing. They're professionals. The outsiders are only temporarily involved with the court, and they're not familiar with the courtroom process. So these could be witnesses, jurors, defendants, and victims. So those are the 2 groups that participate in a criminal trial: professionals and outsiders. When we talk about the judge or a judge, the primary duty is to ensure justice or ensure fairness. And they're the ultimate authority in the courtroom. They can kick people out. They can put people under arrest for doing things wrong in the courtroom. So they can do whatever they want. The judge has complete say in the court. And their key responsibilities are they rule on matters of law. So they decide what evidence can be shown. They answer questions of the attorneys of what can be done. They weigh the objections of each attorney and rule on those. And they decide on the admissibility of evidence, whether it can be used or not. So their primary duty, though, again, is to ensure justice or to ensure balance. Talked about that. They can discipline anyone challenging a court order. They sentence people. They determine guilt or innocence in a bench trial. Bench trial is a trial that is conducted only by a judge. There's no jury. So there's 2 types of trials. There's a bench trial and there's a jury trial. And the defendant has a choice for felony cases to have a bench trial or a jury trial. Which would you choose? Most states have a chief judge or a chief justice. We would call that in California. They serve as a trial judge. They manage the system. They're very much the administrator of the state judges. And again, not a lot of training that goes on as far as administrative or managerial training. They're just a placeholder at the top, and they administrate the judges in the state. For qualifications for federal judges, they're nominated by the president and confirmed by the Senate. State judges are either elected or politically appointed. Almost all states require judges to have a law degree, be a licensed attorney, and a member of the state bar. So if you're going to be a judge, those are the basic things you need to have. And there are a lot of different judges out there. They're lacking in some diversity, so there's a push to hire more minorities, more females, and people of different culture because we want the courtroom to look like the community that it serves. Now we're going to look at the other professionals in the courtroom. So the prosecuting attorney or the district attorney is the prosecutor who takes the evidence and decides if there's enough to go forward with the trial to get a conviction. A district attorney works for the county. The state attorneys work for the state. And again, most district attorneys are elected and serve 4-year terms. And they have a lot of assistant district attorneys. So you can be the district attorney, but then again, you can have assistant district attorneys who work for the district attorney. So again, assistants and district attorneys. Their responsibilities, the district attorney, they supervise their assistants. They serve as a advisor to police in various things that go on. They or their representatives, being the assistant DAs, present the case at trial. They make sentencing recommendations, they file appeals, and they make presentation to parole boards. So, and I was involved in that a lot at the Board of Parole hearings when you'd have a district attorney come in and explain to the panel of Board of Parole hearings members, 12 of them, why a person that was sentenced to 25 years to life should not get out of prison. And they would have 5 minutes to explain how they're still a danger to society, etc. So it's a very important job being a district attorney on the prosecutor side. The discretion that the DA has is huge because they can drop a case, they can accept a plea bargain, they can divert suspects, they can dismiss cases, they can determine charges, they can make sentencing recommendations. So they can do a lot. They have a lot of discrimination. A lot of discretion in what they do. And basically, if they don't have enough evidence to secure a conviction, they usually will not bring a case to trial. So they wait until they have enough evidence that's going to result in a guilty verdict. The defense counsel, that is run by the county in most states, and basically that's the lawyer that's appointed free of charge to the person who's accused of a crime. And again, they can go all the way through the trial. For the defense attorney or defense counsel, they do work with police, they work with other agencies during these trials. You can also have a retained counsel, which is basically a private attorney that you pay for. Fees can be very high, maybe $400 or $500, $600 an hour. So it depends on how much money you have, but everybody is going to be able to have a defense counsel appointed them free of charge because that is part of the process that we have in the United States, and it's one of our amendments. Indigent offense, basically the person that can't afford it, that's where the Sixth Amendment kicks in, and it guarantees the assistance of counsel. And again, the main way to use this service is there's going to be assigned counsel that comes from the city or the county. There's public defenders, and then there's also contractual arrangements that are used with other defense attorneys with the city or county. But it is of no cost to the defendant, which is a good deal. Other members of the courtroom work group, you have the bailiff that ensures order and security. The trial court administrators, they facilitate the smooth running of the court. Again, they're just administrators. The court reporter records everything at a trial. It's not just tape recorded, but there's actually a stenographer who's typing down every word in shorthand. There's the court clerk that maintains the records, does the schedule, swears in witnesses. And then there's expert witnesses who have specialized skills and knowledge, usually have some scientific expertise when they testify as an expert. There's lay witnesses, and these are witnesses that are non-expert. So these are eyewitnesses, character witnesses, or victims. So a lay witness just means somebody that has no experience in being a witness. They're not a professional witness. A jury or jurors, we have a right to trial guaranteed by our Constitution. Usually it's a 12-person jury, can be as few as 6 depending on what state you're in. Jury duties, responsibility of citizenship, and supposedly there's a peer jury that basically the jury is supposed to represent a cross-section of the community where the crime occurred. Does that always happen? Has anybody in the class ever been in a jury or been called for jury duty? If you have, think of the people that were in the jury box at selection time, at the voir dire process. Was it a cross-section of the community, or was it older, retired, white females? Okay, it depends on where you're at. So a lot of people that should be on a jury may not be on a jury. And selection of jury comes from real estate roles of homeowners. It comes from other data. But then again, some people that are not on these roles or in this data are not called for jury duty. So hopefully we can get a better system where we do have a cross-section of the community involved in a jury. Victims, we'll have a whole class on victims coming up. Sometimes they may not be allowed to participate directly in the trial process. They're known as forgotten offenders, or they're known as forgotten victims because they may not be able to speak due to fear, etc. A lot of hardship, and then again, a lot of victims feel that they've been victimized again during the court process if they're a witness and the defense cross-examines them, and again, they relive the crime. So victims have a lot of rights, and again, we'll talk about that at a different class. The defendant, usually they must be present at all stages. Sometimes it could be on video. Nowadays, it does not have to be a visual in the court. Some disadvantages that the defendant can suffer is that some people believe that if you're in court and you're a defendant, then you're guilty. Also, when someone comes in, they can't afford bail and they're in an orange jumpsuit with belly chains on, that may not be a good look for a jury to look at, to see. Whereas somebody that comes in a suit and tie has a totally different look about them when they're a defendant. So the defendant has some disadvantages. Spectators in the press, most of the time the court is open for spectators, family, and press to be in there. And sometimes it's not, because the judge can rule that is not because of the problems it may cause. Admission of cameras and videotape is getting more common. But again, think of yourself. Would you want to be videotaped? Would you want to have photographs taken of you at your trial? So a lot of people do not like that. Okay, that is the review of this chapter. So make sure you read it, look for terminology, which we've gone over, and understand the real basic necessities of the court structure and who the participants are. And again, if you have any questions, just go ahead and post that on the discussion board. And if not, we will see you for the next chapter, chapter 10. Thank you.